Good evening and welcome to Columbia Heights Public Schools Independent School District 13 School Board meeting for Tuesday, May 10th, 2016. I'd like to call the meeting to order and ask you to please rise for the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you and welcome again. Ted, if you would please read the roll.
Asmari?
Here.
Severson?
Here.
Lewis?
Here.
Larkin?
Here.
Palmer?
Here.
Landwehr? Aye. Superintendent Kelly?
Here.
Thank you. Our mission statement, Columbia Heights Public Schools create worlds of opportunity for every learner in partnership with supportive small-town communities by challenging all to discover their talents, unleash their potential, and develop tools for lifelong success. Our core values are community, excellence, collaboration, integrity, respect, courage, and innovation. For the agenda approval, agenda, if I could get a motion to move that forward, please.
So moved.
Molly?
Second.
Laura, thank you. Discussion. Hearing none, all those in favor say aye.
Aye.
Opposed? Abstain? Motion carries. Announcements, May 17th at 5 p.m., school board listening session in the Family Center. May 17th, and on Tuesday, filing for school board seats opens. May 17th at 5:30, the school board work session. May 24th, we'll have a regular school board meeting here in the community room at 7 p.m. May 30th, there's no school, Memorial Day. May 31st, which is a Tuesday, the filing for the school board seats closes. June 3rd, which is a Friday, is the last day of school for the students. Also, Friday, June 3rd at 7 p.m. will be the Columbia Heights High School graduation. On June 14th at 5 p.m., there'll be a subcommittee on policy meeting. And on June 14th, there will be a regular school board meeting at 7 p.m. As far as correspondence, Superintendent Kelly, is there any correspondence?
Mr. Chair and members, there's no correspondence this evening.
Thank you. Communications to the board, citizens and employee representatives. At this time, any citizen or employee may briefly address the school board. The board will listen to brief remarks, ask clarifying questions, and if desired, request that administration follow up. The board will not take action at this meeting on requests presented at this time. Is anyone here to speak to the board? Okay, move on to the consent agenda, which includes the minutes of the April 12th and 26th school board meetings, the April 19th school board work session, the personnel report, and the treasurer's report for March 2016. If I could get a motion to move that forward, please.
So moved.
Natty, second.
Second.
Laura, thank you. Discussion? Hearing none, all those in favor say aye.
Aye.
Opposed? Abstain?
Abstain.
Landwehr abstain. Motion carries. Discussion reports and information items. Reports from members of the board. Board members will report on board activities since their last regularly scheduled meeting of the Board of Education. Hala, would you mind going first tonight?
Sure. Last week, I attended the parent-teacher conferences at the high school, and I was really pleased that in May, when students want to just check out, we are holding them to higher expectations, that we're here, we expect you to be here, and we're still in school. So that was something I was really, really pleased about. When I came over last week to take care of some business of getting me in, I got to talk to someone about the AP exams, and I used to be AP coordinator, and I was really pleased to see that the students get to test here. They get the home advantage when they do it in a place that's close to home, but they're still not doing it in the building where bells have to be turned off or they have to be disrupted by it. And I liked that the whole process of checking in was streamlined, and it was really nice, especially since I've been there and I've done it, and I was really happy to see the way it was.
Thank you. Natty?
Yeah, I've got to attend some sporting events. I attended varsity baseball and softball games, as well as a middle school baseball game. I just finished a subcommittee policy meeting, and I attended the Columbia Heights Athletic Boosters 50th Annual Awards and Recognition Dinner, which was fun to celebrate that with the community and all that the boosters do. I was able to take in the Columbia Heights Community Breakfast with the mayor last week, and also the career celebration with the teachers last Wednesday night.
Okay, thank you. Molly?
I also attended the Columbia Heights Annual Booster Awards Dinner, and it was really just a nice snapshot of seeing all of the donations and things that they've given to the school here. So thank you to the Booster Club. I also attended parent-teacher conferences at Columbia Heights High School. Had an opportunity to attend the Career Celebration Dinner this week. Last week.
Wednesday, yeah.
It's been busy. I apologize. And Highlands Ice Cream and Books. Also attended a couple of varsity track meets and had conversations with many community members and parents. That's it. Thank you.
Laura?
Yeah, I'm kind of running down the list. It has been a busy week. I attended the monthly meeting for 916, the Special Education District. I also attended the Career Celebration, which is always fun, and I'm glad to see that there weren't actually that many people that were retiring. Every time they go through and they do the speeches about all the wonderful things and contributions that our staff has made, I always kind of wonder what's going to happen next year when that person isn't there. So thank you so much for being part of our family. I also attended the Ice Cream and Books over at Highland. That's actually the first time I was able to attend. And oh my gosh, the kids had so much fun. I mean, playing games for books, and it was a lot of fun. I really, really enjoyed myself. I had a lovely meeting also with our superintendent and director of teaching learning, Zena, and Nicole Hollaby, and we discussed a lot of topics regarding my time over at the National School Board Association Conference. I also attended the policy subcommittee prior to this meeting, and I believe I had a couple of conversations with a few people that I'm sorry I couldn't point out who they were, but thank you for your time.
Okay. Thanks, Laura. Ted?
I also attended the Boosters Dinner, and just it's amazing how much how they support our programs. Over $100,000 worth of support every year. That's just financially, and then the time and everything. So thank you so much for all that. It's unbelievable. Attended the career celebration as well, and it's always fun to hear the stories and to celebrate. And then the community prayer breakfast, I was also at that, attended that. The the Valley View Fun Run I was able to go to. Just an amazing turnout of so many runners and parents and students and parents and faculty members. So it was just a great celebration, and I guess this is the third annual. So many thanks to Mr. Schopek for arranging all that and putting that all together. Great community celebration. And then attended the Lions events and talked to many parents and community members. Also attended the WEMAP Finance Committee meeting, West Metro Educational Partnership, and the Executive Committee meeting for that organization. And I wanted to clarify something in our update. I knew that WEMAP had been informed of Columbia Heights withdrawal from the organization, so that wasn't an issue that I was questioning or concerned about. What I did clarified, as I said in the last meeting, is whether Columbia Heights was going to continue its withdrawal from WEMAP and not rescind it as other districts had done. And I had made it clear to them that was our intention, so that we were not going to rescind. I also had a conversation with our colleague Natty Severson. Thank you so much for that. And that's it. Thank you.
Thank you. Boy, it is May, isn't it? There's all kinds of stuff going on. I'm going to just touch on something I mentioned last time because I had the opportunity to go 3 more times, but the play Grease wrapped up the end of April, and they got stronger and stronger with every performance. They had a really nice tribute to Miss Jungers at the end. It just was a really fun time. I know a lot of you got a chance to attend that, so you know what I'm talking about. I also attended the community prayer breakfast, the career celebration for the teachers that were retiring. I mentioned it there, and I'll mention it again, that it's probably one of my 2 most favorite things to do as a school board member, is to be able to celebrate with them when they're wrapping up their careers, the other being coming up on June 3rd, which is the commencement for our seniors as they walk across the stage. I attended the band concert, was that last night? Yeah, today's Tuesday, Monday night. They did a phenomenal job again, just listening to our students perform. I also was in the subcommittee meeting and had a chair meeting with Superintendent Kelly prior to this, and that's the end of my report. Next would be the superintendent's report.
Mr. Chair and members, I attended the MDE Pre-K Grade 3 Principal Leadership Series. This has been going on all year. It kicked off in the fall, and there's been a series of about 5 meetings. Principal DeWitt and Directors Stunkel and Stenvig were a part of this, and there's been a plan put together to make sure that we have seamlessness between and among all of the players to support our students at that critical age. And I really want to thank MDE and the principals of the organization for putting it on, and specifically staff in this district for going. I think that we will be very informed by the work and see some of it implemented in the fall. So thanks to all of you that were involved in that. I also attended Columbia Heights High School All-School Assembly focused on student safety and decision-making. That took place one morning over at the high school, and I want to say special thanks to the Columbia Heights Chief of Police, Nadeau, for participating. I think that I would agree, been at Greece, that was great. The community breakfast was wonderful, and the career celebration was spectacular. Thanks to all that were involved in that. The district continues to meet with the city on planning for the All-American City Award Program that will take place the next leg of the journey in Colorado in June. Good news is that our dynamics from the high school have been accepted to perform at the Cultural Exchange, so that is really great. We think that we will have probably 18 of them that will travel with us to Colorado. And that's a pretty big commitment because I think about 10 of them are graduating seniors. So thanks to them and to Mr. Jakes. I want to remind folks that there's a fundraiser at Noodles and Company over on Central. That's on Thursday. And if you go on May 12th and eat, buy something there, I believe that they will not kick back, but donate some of the proceeds to our trip. And then I think they're doing some gift cards as well there. And then on Friday, May 20th, I just wanted to say that there's going to be the All-American City Awards fundraiser. It'll be at the Public Safety Building. And all are invited, and the Drumline will be performing there as well. So we're looking forward to that. Did I leave anything out on that?
Probably didn't tell you the choir is going to be performing there, too.
Well, you didn't tell me that, but it's always nice to know.
Yeah, they're going to be early on. Just to touch on a couple things for the fundraiser, at Noodles and Company, yes, it's 50% of what you spend they'll give to our fundraising efforts. And then they're actually expecting a really big crowd, so one of the things that they've added to that is the gift card piece, which is if you go in and you don't want to have to wait for food, if you buy a $25 gift card, you get an additional $5 value towards your meal at another time, and again, 50% of that. So you can go in and get the gift card, spend $25, get $30 worth of food, and then the 50% of that would go back. So, and I can touch on what's going on at the end about at the Public Safety Building. So but
That'll be a fun time, too, though. So thanks for letting me know the choir's singing.
Yeah,
That is always good to know.
Yeah, I think they know.
Okay.
I heard that anyway.
I also met with the superintendents in the North Suburban what we call the North Suburban Post-Secondary Success Consortium. And that focus of that consortium really is being sure that we are marshaling our resources to make sure that students are career and college ready. And we're going to be doing some more work together to see if we can be sharing staff or sharing curriculum, making better opportunities for our students. And that is in collaboration with at least one college. We're working on another one, and then we will look at some career tracks as well. That seems to be going on very well. As Vice Chair Palmer mentioned, we did have a debriefing on the Boston trip and to NSBA, the Leadership Conference, and many good ideas came back from that. And so we are very happy as an admin staff when you share the ideas that you learn at the conferences. And so we'll be reporting out. We're studying some of the ideas, and we'll be reporting out to the board if we're going to take any action on some of those ideas. I, too, attended the subcommittee on school board policy, and I talked to or met with many of you around the table, so thank you for your time, and that concludes my report.
Thank you. Thank you, everybody. Next up will be item C, which is desegregation lawsuit overview. We have the privilege of having Paula and Nell present some information on that. I had the good fortune of being able to hear you speak at AMSD here. Would have been, I think, last month, the month before, but so you have some really good information, and the hope is that when we're done tonight, we all have the same information and be able to ask the same questions if possible of you. So thank you and welcome.
Sure, thank you. I don't know if we have a PowerPoint, or if you want me to put up a PowerPoint, or do you want me just to speak about it? And
If you have your PowerPoint, that'd be great.
I do. Should I just plug it in here?
And the reason I say that is because for the viewing audience at home, sometimes when they see it later, it's nice for them to have a framework as well.
Let me scoot over and see if I can get this up.
Ryan?
Okay, so I didn't change the title, so I apologize. But this was the PowerPoint that was presented to the MASA group, Region 9, on April 27th. Nell and I were both there at that one as well. So it's basically the same PowerPoint. So if you're at the one at AMSD, we just made a few corrections and changes after that. And yeah, essentially this arose, or our opportunity, so we thank you so much for inviting us in. I want to just introduce Nell Matthews a little bit. Nell and I have been working together off and on for almost 30 years now, practicing law. I know, we date ourselves, practicing law. We both worked together at Ryder Bennett in private practice, and then when I went over to Minneapolis Public Schools as their general counsel in the early 90s, Nell handled all of my litigation work and defended the district very, very well in all of the litigation work. So whenever I deal with an issue around litigation, she's my go-to person. She's the person that I call and ask to come in and help me analyze the case, and not just analyze the case from where it is, but really the path and the journey of where the case is going to go. The way that we kind of look at cases is we always look at the history. We always look at what is the path and how do we find ourselves here, right? People don't seek out a remedy in court. It's usually the last resort. A lot of us feel that it's the first resort, but generally it's the last resort. It's something that's been brewing for a long time, and they don't think they have any other remedy but to seek a remedy in court. Unfortunately, once you get to court, there's very few choices that you have with regards to remedies. The court is very limited on how they can resolve a lawsuit or litigation. But when we're dealing with constitutional analysis, oftentimes that's where you find yourselves. And in the area of education, the courts have been the main focal point for determining issues around constitutional rights of students and employees. So I have the just the honor and the privilege of being able to teach education law at the University of Minnesota and St. Thomas to people who are working on their principal's licensure and their superintendent licensure. And whenever I do that, I always start at that point of what the struggle is. I always, let me just make sure I'm going the right way. I always ask the class, what are we struggling with and what are the issues? When you're dealing with anything around First Amendment rights, due process, religion, torts, you know, when someone gets injured on school property, employee rights, labor unions, everything you do every single day, what you touch, both with regards to administrators and teachers and principals and school board members, has to do with constitutional rights and the amendments. So too is the issue around equal protection and equity in education. The struggle that we're dealing with right now in the state of Minnesota is a case that was recently filed with the state. The plaintiffs have brought action against the legislature. They brought action against the Minnesota Department of Education. They have also brought action with the governor. They have named some individual legislators in a suit called Alejandro Cruz Guzman versus those particular parties. They are claiming that Minneapolis and St. Paul public schools are segregated based on race and socioeconomic status. They are claiming that the state, and Nell will explain this further, through a series of pattern of and practices and policies, intentionally and unintentionally, have created or exacerbated the situation. And they feel that the only remedy is to have a metropolitan school district in order to eradicate segregation in the state of Minnesota. They have brought this in the state. This is not a federal case. And they have brought it pursuant to the Education Clause. The Education Clause, I type, that's our struggle. It says that a uniform system of public education and public schools, the stability of a Republican form of government depending mainly upon the intelligence of the people. It is the duty of the legislature, now that's really important to note, and we'll get back to that, to establish a general and uniform system of public schools. The legislature shall make such provisions by taxation or otherwise as will secure a thorough and efficient system of public schools throughout the state. That is pursuant to the state constitution. That's the struggle. What is basically a general and uniform system of public education? The plaintiffs believe that the state has denied children in Minneapolis and St. Paul of their right to an adequate education pursuant to the state constitution. And I believe that we have to go back in order to really understand how we go forward. So I always start with Brown v. Board of Education. I actually start before that. I start with Plessy v. Ferguson and the 13th Amendment. But because we don't have that kind of time, and this isn't one of those, 5-part series, we're going to do the Reader's Digest version. So let's go back to Brown v. Board of Education. And what did Brown v. Board of Education teach us about desegregation, integration in public schools? Brown v. Board was brought in 1952. It was argued, and it wasn't decided until 1954. They actually argued that case twice. And the reason why they argued that case was because they had to determine what this whole issue is around separate but equal in education, and why is separate schools, why are they inherently unequal, and what is it about that? And so they needed to really take a look at what was going on in society at the time. We know that there was a prior case, Plessy v. Ferguson in 1896, that determined that the community could be separate as long as it was equal and people were provided equal resources. We also all know that that's not actually how it materialized, that it was actually very unequal both in society as well as in public schools. Brown was actually a case that was brought by 5 different states. Over 200 children came together, and under what we phrase as diversity jurisdiction, because the Supreme Court felt that there was basically an issue that they needed to decide that would impact the entire country. And that was whether or not the plaintiffs' claim that they were denied admission based on race violated the 14th Amendment of the United States Constitution. And so they took that up, and they thought about that, and they argued that to the Supreme Court. The issue that was presented was this: does segregation of children in public schools solely based on race, even if physical facilities and everything else is equal, deny children of the minority group an equal education opportunity? And in order to do that, they had to assume that all of the facilities were equal and all of the resources to children were equal. We know at that time in the 1950s, about $150 was spent on Caucasian children and about $50 was spent on children of color in the United States. But they set that aside because they didn't want to just deal with tangible factors. They wanted to figure out what was going on intangible. They also had to determine, well, then what is equal? What do we have to look at to determine what is equal? And the court said, in these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. And such an opportunity, where the state has undertaken to provide it, must be provided to everybody on equal terms. So under the 10th Amendment, what they were saying is, if a state decides to provide and fund public education, it must do so to everybody on equal terms. In there lies the struggle. What is equal? They looked at all of the schools. They decided that they were going to, just for the purposes of the argument, equalize the schools based on what their structures were. But in the process of this, there was a couple, an African-American couple that were both psychologists, and in the 1940s, they developed this experiment that they did. They took, and we call it the doll experiment, they took white children and they took African-American children, and they presented them with a doll. And the only difference in the doll was the color of their skin, their eye color, and their hair. And they asked those children, which is the nicer and the better doll? And the children overwhelmingly chose the white doll, the one with blue eyes, the one with blonde hair, and they said that's the better doll. They also asked children that went to segregated schools, what is the better doll? And the children said, both white children and black children said, the white doll is the better doll. They were able to use that information and bring that information into court. And for the first time, the court was able to look at objective data that suggested that segregation and creating a dual system of education by law based on race created psychological trauma to black children. And based on that information and evidence, the court was able to determine that it's not just about tangible physical structures. It's actually about equity. It's actually about what happens to the child in a segregated educational system. And so you have Justice Warren, who was our Chief Justice at the time, who wrote the decision in Brown v. Board, basically stating to separate them, black children, from others of similar age and qualifications solely because of their race. Solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. He said, whatever we thought back in the day with Plessy v. Ferguson, it's not the way we can think now. Separate but equal no longer has a place in our society. It must be undone, and he overturned that case. And in overturning that case, he made a determination that separate but equal needed to be overturned and schools needed to be desegregated. Now, that was in 1954, okay? And we only have desegregation now in our public schools. We still have legal segregation in society until 1964 with the Civil Rights Act, and then we don't have open housing occurring until 1968. So we still have a lot of legalized segregation occurring in the United States. And in places in states where there isn't legalized segregation, we still have what's called de facto, or in housing and real estate, we have what's called redlining, where we intentionally move groups of people based based on culture and based on race into different neighborhoods. That was what was occurring in Minneapolis at the time. So it's a very short period of time between 1968 and 1971 when we get this case called the Booker case. And the Booker case really set the precedent in Minnesota for race relations in public education. Booker in 1971 was NAACP, 3 students that were situated in the city of Minneapolis. They brought suit against Minneapolis Public Schools. They bring it in federal court. They bring that case claiming that Minneapolis Public Schools created intentional policies and practices that exacerbated segregated schools. So to give you the Reader's Digest version, they looked at a 4-part test, the court did. They looked at whether the state and or school administration had taken any action with the purpose or intent to segregate. They looked at whether the actions had the effect of creating or aggravating segregation in the schools of the district. And then they looked at whether the segregation currently existed in the district. And if it did, then they looked at whether there was a causal connection between the acts of the school administration and the conditions of segregation in the district. They looked at the rule. They said, under Brown, if there is segregation, it's unconstitutional. They looked at this other case called the Keyes case, and they looked at those 4 factors that I laid out for you. And then they looked back at Brown and they said, and if the district is found to be segregated by law, it is required to integrate. And that's going to take us to where Nell is. But they look at this philosophical deviation from Brown. From the first time they say, we don't really care about the psychological impact because we know that it's morally and legally wrong to segregate kids based on race. What we believe is relevant now is whether or not they're taking affirmative actions and affirmative policies and practices to create this system of segregation. That's what we're going to look at. We've already proven that there's a psychological impact. We don't have to prove that all over again or even look into it. They decided that the school participated in building different schools of different sizes, that they drew attendance lines, that they had a transfer policy, casual and a formal transfer policy, that they had attendance zones, that they had employment practices. They assigned teachers of color to black schools. Those teachers had lower seniority, so whenever they had to do some downsizing, they were the first hired, the first to be let go. And they also decided that there was a high degree of residential segregation due to discrimination, and that they admittedly were pressured against desegregating the schools from the school board was based on their constituency and their voting practices. And so they enjoined the school district. They said that the school district can no longer use those policies and practices, and they have to take affirmative measures to integrate their schools. The last day of the trial in this case, Minneapolis School District adopted a desegregation plan, and the court allowed that plan. It was active until about 1983. There's this case called Booker 2 that came into court where they tried to get excused from the court under the jurisdiction of the court. They disallowed it until 1983. They tried about 10 or 12 times, and it really had to do with whether or not they were complying intentionally with the desegregation mandate set out by the court and by the plan that they admitted into evidence at the court. So I want to skip the Skeen case, and then I'm going to take you back to the Skeen case because that's important. But I want to take you up to 1995 with the NAACP lawsuit, because the NAACP lawsuit in 1995 really mirrors a lawsuit that we're all dealing with right now, today. In 1995, the NAACP, Minneapolis at that time, created this program called Eliminating the Gap. They saw in the schools that they had over 80% kids of color and poor kids, and that even if they bused kids across town, they couldn't find a way to desegregate these kids and integrate the schools. They did not have enough white children within that school district to do a good job of desegregating the schools. So instead, what they wanted to focus on was being able to have parental inclusion, a lot of parent involvement. They wanted to focus on early childhood education, and they wanted to focus on neighborhood schools. In order to do that, they sought a variance from the state Board of Education on the deseg order that they were required to comply with. And they went forward and asked the state for a variance. The state granted that variance. NAACP was opposed to that variance and testified against it. And they also threatened a lawsuit that if they granted the variance that they would sue. They granted the variance. A month later, the NAACP sued. They did it for the first time in state court. They did not do it in federal court. And they did it based on the decision that was made in Skeen. And that's why I'm going to go back to Skeen. Skeen basically was a case that was brought in 1988. We had 52 outer ring school districts, 24 intervening school districts. The case with these school districts was basically claiming that Minnesota's school finance system was unconstitutional. And it was unconstitutional because it was not uniform, and school districts receive disparate amounts of government aid. Basically, they were saying that the levies that the different communities were able to raise was unequal. And because it was unequal, it was creating more resources in more affluent communities and less resources in other communities. And they wanted the state to intervene and to level that out and to balance it out. They won at the trial court level. They lost at the Court of Appeals. The interveners and they appealed to the Supreme Court, and the Supreme Court agreed with them. And the Supreme Court basically said that all of the school districts basically are providing kids an adequate level of education. They also said that the state met that burden of providing kids an adequate education, and that their financial obligation of providing a uniform and fair education was met. They also said that all children did have a fundamental right to a general and uniform system of public education, and that it had to be adequate. They established a minimum standard that the state must meet in designing an educational funding system, and they said that they did that. Anything above that, communities are allowed to do on their own, and that is not unconstitutional. So that's why I bring that up, because we go to NAACP and they say that the state is not providing the children in Minneapolis an adequate education pursuant to the Constitution, and that it is inequitable based on the state constitution of adequacy. That's why everybody called it the adequacy lawsuit for so long. Right on the eve of trial, in the NAACP lawsuit, they settled the case. Now, what's interesting to note is that even though Minneapolis was, the students belonged to Minneapolis Public Schools, Minneapolis was not named in that lawsuit. It was the state of Minnesota, MDE, the legislature, and the governor, but they were Minneapolis Public School children. The reason why they weren't named in that lawsuit was because it was a constitutional case. It was a constitutional argument, and so they weren't named in that suit. Minneapolis did not then actively participate except for to cooperate with the Attorney General's office and provide all of the data that they needed to. Late in the game, Minneapolis started to be involved in settlement negotiations, and they created the Choices Yours program on the eve of trial as part of the settlement. That Choices Yours program lasted until about 2005. So the case settles in 2000. The program gets expanded in 2002, I believe, and in 2005 they go to court and they get the legal settlement on the NAACP. It expires pursuant to their settlement agreement, if that makes sense. So that leads us now up to 2016, November, when once again the same attorneys in the NAACP case in 1995 bring a lawsuit on behalf of Minneapolis children, now St. Paul children. They bring this case on behalf of all children of color and all children that they find themselves in poverty. So socioeconomic status is now added to the lawsuit, and they bring it against the state. So again, it's a state case, and again, they say that the state is providing an adequate education based on those factors. And so I'm going to chip it over to Nell to kind of fill us in on where we are with Alejandro Cruz Guzman.
Thanks, Paula.
Sure.
You want to switch? Okay, what do I do? Just hit the,
Get this one.
okay, great. So how many of you have been involved in much litigation? I mean, I assume that you have been, I assume you've been sued. Hope I haven't offended anybody by saying that. That generally happens with school districts. Well, as a refresher, once a case is sued out, it has 4 phases. The pleadings phase, which is the preliminary, plaintiff says what plaintiff's complaint is, defendant or defendants say why they don't agree with plaintiff, and if there are any cross-claims or counterclaims, then those are brought in. The second phase is called the discovery phase, and that's very time-consuming for school districts because that means that you're first identifying the documents, and you're exchanging the documents, you're answering under oath written questions, and then you are often required to produce witnesses for deposition testimony, which is sworn testimony in front of a court reporter and questions asked by all the attorneys. And usually the discovery phase, especially in a complex case such as this one, can take quite some period of time and be very expensive. After discovery is completed, there's the summary judgment or dispositive motion phase. And what that means is the parties go to the court and say, there are no facts in dispute on issue A, B, or C. As a matter of law, you need to rule in our favor. And there can be some rather harsh results as a result of the summary judgment phase. There can also be some rather good results on behalf of school districts because they can cut some claims that don't have any merit off at their knees before you go to trial. Paula mentioned the Skeen case. That was tried for 67 days in Wright County. The interveners spent close to $1.5 million in connection with that. And they were interveners. They weren't even the primary people in the fight with each other. So then the fourth phase, of course, is trial. And preparing for trial and going to trial, if you've had that experience, you will understand that there are some very specific rules of court. You don't get to tell your side of the story. You don't get to present all of the facts that you think are important. It's a very structured way of presenting the facts to the fact finder, whether that be a jury or whether that be a judge. And sometimes it feels a little bit unfair. You have to remember that the fact finder, whether it be a group of people who are sitting on the jury or the judge themselves, will never know as much about the facts, the case, the impact on any of the parties as the parties do. They will never know. They just can't. They can't absorb all that information. They don't live in your venue. They don't understand the significance. People, it's human nature that you kind of fade in and out. As my son liked to say, says about our dog, squirrel, so it's human nature to engage in that kind of behavior. And when you have a fact finder, no matter how diligent and dedicated and hard either the jury or the judge is behaving, they can miss things. So that's all about what happens in a lawsuit. And we are in a lawsuit right now. And as Paula mentioned, the parties to the lawsuit, there aren't any school districts that are named in the lawsuit. The parties are plaintiffs, parents, and children in Minneapolis and St. Paul Public Schools, along with one Minnesota nonprofit that provides services to children of families who are socioeconomically challenged or are, fall within the race category with regard to this case. And Paula went through the defendants. What's interesting, and I want you to pay a little bit of attention to this, charter schools were not originally named in the case. It was just the plaintiffs, the parents and the children, and the state of Minnesota folks. But the case was filed in November of 2015. The state still has not filed an answer yet. So we are still in that first phase, the very preliminary pleading phase, because the 3 charter schools, parents and children, sought to intervene. It was a hard-fought, hundreds of pages of pleadings between the charter schools and the plaintiffs. The plaintiffs did not want the charter schools to intervene. And the charter school said, hey, you know, you mention us in your complaint, and you say that charter schools are either the cause or the result, or they are segregated, and they're allowed to be that way by parental choice pursuant to the MDE and the state of Minnesota. And that's wrong. That's what the plaintiffs say about the charter schools. And the plaintiffs are saying, no, we don't need to have the charter schools in here. We're focused solely on the either wrongful, negligent, lack of attention actions by the state of Minnesota, whether that's the Department of Ed, whether that's the legislature, whether that's the individual House and Senate, or the governor, all of them together. But the court found that charter schools have an interest. It'll be impaired by the disposition of the action as sought by the plaintiffs, and so they're allowed to intervene in the case. And the significance of that is nobody else was looking out for the charter schools' interests, and that's why the judge let them join the case. So Paula went through the claims that the plaintiff is making. Essentially what it boils down to is it does not matter why or how it happened, but that children who fall into who are socioeconomic challenged or are children of color are being segregated in schools. And it's not just Minneapolis and St. Paul schools that they mention in the complaint. They mention other school districts, that they're being segregated, and they're either in racially isolated schools or racially isolated districts. That is per se an inadequate education. We know. We don't have to go back and prove that if you have segregation, that's wrong. It's already been well established. So that hurdle has been leaped over a long time ago. And it doesn't matter whether there was ill motive, bad intent, folks weren't paying attention, they weren't, don't understand the consequence of the actions or the legislation that they passed or the rules that they made. The fact of the matter is, schools are segregated, kids are not getting an adequate education, and you, state, need to do something about it. And here are the things that they say, the plaintiffs claim, are the state's alleged failures. And many of these are actions taken by the local school districts. And what the plaintiffs are saying is, state of Minnesota, you either mandated, suggested, or allowed, or just turned your eye away and didn't pay any attention to many of these policies: open enrollment, transfer policies, formation of charter schools, the drawing of the school boundaries, discipline and suspension policies, assignment of teachers, all of these things. Improper use of special education services, magnet schools, all sorts of programs that Minnesota has prided itself on excelling at for many years. But this is what the plaintiff is saying that the state of Minnesota has done wrong in allowing this local action, local control by school districts. So we talked, Paula gave you the backstory, Booker, NAACP scheme, and there's been a lot of discussion in those other cases. The federal court case, understand that the federal Constitution does not mandate education. State constitutions do, and that's why they're seeking, and the federal Constitution and federal judges will take steps, and they will intervene when there's clear intentional segregation, and they'll fix it. They may not always do what you want them to, but they'll do something. But the reason why the plaintiffs are focusing on the state constitution is because we have actual language, not only the uniform and general system, but now we have the Skeen case that's expanded that, a uniform and general system that results in an adequate education. And it doesn't matter if you have, transportation policies that have resulted in segregation. It doesn't matter how history has shaped this. The fact of the matter is it's happening today. And so the plaintiffs are claiming there's a strict liability standard, and you have to fix it. It doesn't matter how you did it, but you have to fix it. The interesting thing is, in the lawsuit, there are a number of metro area school districts that are mentioned by the plaintiffs in the complaint as having engaged in some of these purported alleged failures, open enrollment, transfer policies, magnet schools, et cetera, special, PSEO programs. And those include Bloomington, Rosemont, Apple Valley, Egan, Hopkins, Burnsville, Osseo, East Carver, North St. Paul, Maplewood, White Bear Lake, Anoka Hennepin, and Minnetonka are the ones that they've mentioned. And the only reason why that's important is because, remember, they don't sue any of these school districts. They're saying that the actions of these metro school districts surrounding Minneapolis and St. Paul have resulted in open enrollment and pulling white children out of Minneapolis and St. Paul. But they also say that even in these metro school districts themselves, they have racially isolated schools because of programs that they've adopted, which has shunted some children into some schools and pulled others away. And the reason why this is significant is look at the third bullet point here. In their complaint, the plaintiffs state, the state has allowed numerous schools and suburban school districts to become segregated on the basis of race and socioeconomic status. Desegregation cannot effectively be achieved without a remedy embracing the entire Twin Cities metropolitan area. That means you. That means every school in the metro area. And now, we always have the kind of old horror story of busing children 3 hours across. And that's the thing that comes to mind easily for people because that's what they've always heard. But there are certainly lots of other options in those alleged failures that the plaintiff is criticizing that the school districts are engaging in. And right now, Paula and I went to listen to the arguments, and we'll talk about that. So the state of Minnesota has not filed an answer. They filed a motion to dismiss. They've said, you haven't brought a suit, you haven't done what we needed you to do, you measure outcomes, we measure inputs. So the fact that children of color and children who are in economically challenged status class, the fact that they are not performing as well as children of the same age who are Caucasian children, it doesn't matter. We've given them all the inputs, and too bad, and we don't need to figure that out. Which, of course, to me suggests is separate but equal. I mean, really, if you're only
Can be
measuring,
considered de facto.
yeah, if you're only measuring inputs, then what do you do with the fact that you have children that are failing?
And I think that's exactly what the judge was asking counsel
Yeah.
during the oral arguments is, what do you mean by that?
Right.
You don't care about outputs? So that's going to be a really challenging question for the state to answer.
Right. So the state has taken the position that there's no basis for the lawsuit. It should be dismissed. The state also said, you haven't named the correct party. You didn't include any school districts, even though you mentioned them in the complaint. You haven't mentioned any school districts. None of them are defendants. And so you should dismiss because you don't have necessary parties included in the lawsuit. And then there were some other motions between the charter schools and the plaintiffs because the charter schools would like the judge to make a declaration that their exemption from the DSEG rules is constitutional, which is a little bit further afield than what the plaintiffs want to do. And of course, the plaintiffs don't want to get sidetracked on their, they've got lots of proof problems, don't get me wrong, because there are all sorts of, problems with their complaint. And they don't really give any remedy. And what they repeatedly said to the judge, which I found really interesting, was, oh, judge, we don't want you to figure out what to do. We just want you to say the state is wrong and they need to fix it. And that brings us to our next quick mention. There are two cases that you need to pay attention to. One's in Connecticut and was in state court and was in 1996, so 20 years ago. And similar situation, children were in segregated schools, similar constitutional language, not exactly the same. And the court found back then that these sort of de facto actions of allowing transfers, open enrollment, those weren't intentional. They weren't motivated by bad intent. people weren't making these choices and allowing these things to happen because they wanted segregation, unlike, back in the 50s. But the court said, okay, it's de facto, it's unintended, it still results in segregation. So, we're not going to get all caught up on whether it was intentional or not. The end result is that our children are being segregated, and that isn't right. And so what the court did, there was a trial, and what the court found in Sheff was that the state had a constitutional obligation to address and correct this, and then sent it to the legislature to fix, and the executive branch to fix. And since 1996, there has been a number of pieces of litigation that have resulted from this. First of all, that the legislature isn't moving fast enough, that, they created a work task force that came up with 200 ideas of how to address segregation, and a year and a half later, they hadn't really narrowed it down. They eventually narrowed it down to 50, and then they had to pass the ideas through the legislature. So kind of the unwieldy nature of how politics moves has been a challenge in Connecticut. And 20 years later, just recently they had another lawsuit on this. And, the kids who were initially involved in the suit have long since graduated. And, the problem that we see is you're spending money, you're spending time, you haven't fixed the problem. It's 20 years later, you've lost, 2 generations of kids almost? And you still haven't, figured out a remedy. So we learned from Sheff that maybe just having the court announce or declare, yes, this is unconstitutional, now legislature go fix it, might not be the fastest way of getting things done. Then we have a federal case out of Michigan, Milliken v. Bradley. This was a very interesting case from a procedural standpoint in that essentially the Detroit Board of Education and students in the Detroit Urban District went to federal court and said, we have segregated schools, fix it. The court said, well, let's see, what should we do? And then decided that there should be metro-wide integration, and then allowed the suburban school districts to intervene, but would not allow them to present any evidence or information about how this might impact the suburban school districts, or what they thought would be a good resolution. It went up to the Supreme Court. The Supreme Court essentially said, we're not going to require that the suburban school districts be part of the problem when it's not been established by the evidence that they had any cause in creating the problem. And we think that a metro-wide school district could have all sorts of problems, because we recognize it's long been a tenet that local control of education is really important. And how would you do financing, and how would you do control, and how would you elect the school board members, and would school board members from the east metro area of Detroit be controlling children in the west metro area? So all sorts of roadblocks that were thrown up by the Supreme Court. But essentially, what I think the takeaway from this case is the court, again, was not too worried about the fact of whether it was intentional or unintentional actions that result in segregation. The court just doesn't know how to fix it. So what we have with Cruz Guzman is we have a lawsuit that is asking for a metro-wide solution to segregation. We're in the preliminary pleading stage. The court heard these motions on April 14th, has 90 days to issue, the judge, Robiner, has 90 days to issue her order. She could take less. It's kind of a complicated issue. She might take the whole 90 days. And then after she issues her order, then, if she doesn't dismiss the case, then the state will need to answer, and then discovery will start. Now, the plaintiffs, when they originally filed this case back in November, had asked that they have a trial in January of 2017 because of this motion practice and the fact that no discovery has been conducted. I assume that will be pushed back until probably about 3 or 4 months, probably mid-April, May, depending on how aggressive the judge wants her schedule, so to allow for additional discovery. So you have intervention by the charter schools because nobody was protecting their interests. Paula mentioned the parties in this matter. So you have the plaintiffs, who are children in Minneapolis and St. Paul school districts and their parents. You have the defendants, who are all either, the educational regulator, MDE, or, elected politicians, the Speaker of the House and the President of the Senate and the Governor. You have their lawyers, and their lawyers are fine litigators, and they did a great job in preparing their their written pleadings and making arguments to the judge. But, your litigators advocate on behalf of the party that they represent. They don't advocate on behalf of anybody else. Because that's their job. So the question for school districts, which Paul and I have addressed several times before, is, what do the metro area school districts, what is their consideration? What is the impact on them? Who is representing their interests? And who is at the table on behalf of the educators who are actually implementing whatever policies, procedures are being proposed, or whatever policies and procedures are being objected to that are currently put into practice in your district and in other metro area districts.
And one of the things that I want to emphasize that Nell has said and that I have said throughout is we've basically told you what the position of the plaintiff's claims are. These are allegations. They are claims. They have not been litigated. They have not been substantiated or found to be true. They are just allegations at this point. So I don't want you to mistake that they've made these findings and these are facts. But they do have data that they're using, that they have included in the complaint. And part of that data is the achievement gap data, and a part of that data is the socioeconomic data, and then part of that data obviously is the demographic and where these children reside. And that's where they're getting some of the information to put into the complaint and to make these allegations. So they use a broad sweep, but they are using some data. But it will get really fetted out during the discovery stage when we're not even there yet, because we have these dispositive motions, or not dispositive, but we have these motions on the pleadings going on right now. So, yeah.
I was wondering if I could get a copy of the PowerPoint, because I'd actually like to look into some of these cases a little further.
Sure, absolutely. I'll make sure that Superintendent Kelly has
Thank you.
a copy of it. We did you the real short version. There's
Oh, yeah, I know.
Great
There's
late night
volumes.
reading in here.
Volumes.
If Jimmy Fallon doesn't have anything good going on, read this. You'll just be fascinated.
If there's lots of data in there, I'd really have a good time with it. So.
When you guys presented it, when I listened to you previously, some of the conversations was, not necessarily giving any kind of counsel as to direction that school districts should go, but I kind of walked away from there with the impression that we don't have to, if we were to go down the path of intervention and join with other districts or whatever the case, it's not like we have to do something tomorrow. Based on even the timeframes and stuff that you're talking about, of where they're at.
Yeah, generally with litigation, you if you're going to intervene, and as I said, you intervene because nobody else is looking out for your best interests. And so you need to be at the table, you need to hear, you generally, parties intervene before the discovery starts. Because you want to hear what the questions are being asked of the witnesses. You want to see kind of the roadmap that's being laid out by the plaintiffs. So you can predict what they're going to suggest would be remedies that could fix this problem, or that the MDE is going to suggest as remedies that could fix this problem, or what the charter schools are going to suggest as remedies that would fix the problem. So it's good to be involved in the discovery, at some point in the discovery phase. And generally, as I said, the court has 90 days to issue her order. That would bring us to mid-July. And then it takes a while for people to get discovery going, because if you serve written discovery, you have 30 days to answer. Generally, you do written discovery and you do document production well before you start taking depositions. So the discovery phase itself could last 6 to 8 months.
The law allows intervention as long as you do so in a timely fashion. What's timely, right? Well, essentially, you have to look at the case and say an untimely intervention is when maybe discovery is over or people don't have an opportunity to respond to your papers and what you're presenting, or it's, before trial. So you definitely want to take timely action. So you want to, you definitely want to find out whether or not is this case going to get dismissed? What's the judge going to do? How is the state going to respond? That's going to inform you of your own path and what you need to do. But and so that's going to create, I think, give you more information about timelines. So it's not something you have to take action on today, but it is something that you want to watch and see what's going to happen.
And I think it's important to remember that 97 to 98% depends on which research model you're looking at. 97 to 98% of all civil cases settle. They just don't go to trial. It's too risky, it's too expensive. There are often a myriad of proof problems. A lot of times parties position themselves through litigation to go to a mediation or a settlement conference to try and resolve their differences, because that's really what they want to do. I think the important point here is, this could be the 2 or 3% of the cases that get tried, but we've seen what's happened in trials of this type of nature, civil rights nature. I mean, there hasn't been a great resolution. And what's really important is whether you have a voice that is being presented, heard, and considered in creating the solutions. I mean, school districts all have the same desire, is to make sure that their children achieve. And if the school districts can be part of this solution in making sure that the kids have the best opportunities, environment, programs, coordination among school districts to be able to succeed, that is the end goal.
That's the opportunity.
Have
That's
you
the
s-
opportunity that's presented.
I'm sorry. Have you heard or seen of any other of the metropolitan districts that have taken the steps to intervene at this point, or is everybody kind of where we're at, which is like what's really going on?
Yeah, and I can let Superintendent Kelly speak to that a little bit more, but everybody is having this conversation. And this is the opportunity for people to have this conversation. With or without the lawsuit, I think people are having the conversation of saying, what is this data telling us? Where are we with regards to equity in education and the achievement gap? And what are we doing with regards to figuring out solutions? And is this the place and time now to really dig in deep and work together to find an opportunity to create solutions to that issue? And even if this case got thrown out tomorrow, doesn't that tell us that we have to do some forward action and affirmative action to be able to try and resolve those issues? All of those kids of color, kids of socioeconomic status, they're in all of our districts. This isn't about 1954 when you have, a community that is segregated by race. This is about kids in all communities making sure they have access, opportunity, and an equitable and adequate education. And so that's a conversation, I think, that if anything that comes out of this, you are already having that conversation. Your mission statement speaks to that conversation. That is your goal. And so this is something that you strive towards. But what this case does create for you is maybe the opportunity to speak with other schools about what are they doing, what's out there, what's on the horizon, how do we really grasp this and solve this pursuant to what the plaintiffs are saying. I think that's really kind of how this case speaks to me. And if I could give any suggestions that were not legal advice, that's one of the suggestions that I would make.
So I have a question. So it's always a good time to talk about equity and how we're going to meet the needs of all our students. But what does intervening look like relative to this lawsuit? What does that mean for us?
Okay. So that's one of the questions. It's a great question, but I'm going to have to probably defer that question because that is trending down that road of providing legal advice, and I don't think we should do that in a public forum. And we kind of want to stay more on the informational level. And it really means, it is to each district very individual based on what your data is telling you, and based on where you are geographically, and based on where you want to be results and things. So there's a lot of factors that go into it that you would have to work with your board, with your leadership, and with your superintendent to figure out. But I think that's a great question and a conversation that maybe you should have. Yeah.
And if I can just interject from a procedural litigation standpoint, if someone's going to intervene, as Paula said, it should be timely. Given the circumstances of this case, it doesn't really make sense to intervene before you have the judge's order and you know what the heck's going on. What if she dismisses it? Now, that's not to say that you wouldn't want to do your own introspective thinking about what's going on in your district, because if it's not this case, it's going to be another one. I mean, we have a case in Wisconsin. I mean, there's a number of these cases where there are problems with children achieving the education, and
They're bubbling up.
Yeah.
They're bubbling up in OCR.
Yeah.
The Minneapolis, St. Paul just got brought into a case, District 197, the Teacher Tenure Act case. It's
similar.
Very similar, based on a different statute, but the plaintiffs are basically saying that there's inequity in educational outcomes, and it's inequitable because of the Teacher Tenure Act allows or mandates that school districts keep teachers based on seniority and not based on performance. And because of that obligation pursuant to the law, they don't have the ability to be able to utilize their teaching staff to better address student achievement. And so state, once again, you need to take a look at that Teacher Tenure Act, and you need to find it unconstitutional, and you need to do something about it.
Well, and I see why the plaintiffs are taking this approach. It's because if they took a piecemeal approach with each district, there isn't enough there to get the end result that they desire, which is, kind of an overall systemic approach to an adequate education. And a systemic approach that's based on outcomes,
Right.
not on inputs.
Not on inputs.
Okay, so the way that I'm understanding this is that the plaintiffs are generally just they want this to be a metro-wide school district where everything is,
That's
but they
one-
don't want the judge to make the decision on how to solve the problem.
Yeah.
Yeah.
You nailed it.
exactly it.
Okay, that's what I was understanding, and I was hoping it was going to be a bit more clear than that.
No, you nailed it. And that's exactly what the defendants are saying. It's not that clear.
Right.
They're saying you're not being clear enough, and therefore you need to go back and you need to rewrite your complaint so that we can understand exactly what your remedy is and what you want from the court. And the plaintiffs said, we've been pretty clear. And the clarity that we're telling you is that it's not the judges or the court's role to determine what the remedy should be. It's only their role to determine whether or not segregation exists. And then based on Brown, when segregation exists, it is the obligation of the state to eradicate it.
Right. But that hasn't worked so well so far, according to the plaintiffs.
According to the
Yeah.
plaintiffs.
Ted?
Isn't being an intervener actually becoming a party to the lawsuit?
Yes, and thank you for asking that question, because that's something I wanted to address. So you have the plaintiff, you have the defendant, the two gladiators that are going at it with pitchforks or, swords or whatever, gladiators, lions? Anyway, sorry, I'm getting a little mixed up. My lack of history is coming out. It's making me really nervous in this setting. But so we have the plaintiffs and the defendants. They are very much diametrically opposed. And then we have the charter schools who have intervened, and they've got a slightly different agenda. And the plaintiffs are like, we don't want to get sidetracked on your different agenda. We don't want to spend the money on your different agenda. And then the state of Minnesota is like, no, and we don't want that different agenda. We're not quite comfortable with that since we changed, had just tried to change the rules through an administrative law judge proceeding, making the charter schools have to comply with the DSEG rules. So that's a little backstory side, argument that has nothing to do with the school districts. So you would be a party, but you would be a party because you have an interest that is not being represented by anybody else. The plaintiffs, the parents and children, Minneapolis and St. Paul, they don't represent the metropolitan area school district's interests, or in your case, the Columbia Heights School District's interest. The defendant is your regulator. They don't represent your interests. A regulator would be hard-pressed to represent your interests. I'm not sure you'd want a regulator to represent your interests. And then the politicians, you see in the city of Detroit now, we have emergency managers that have gotten appointed to run the school districts. And those have been hugely politicized, problematic, and, from the media reports, not very well-performing people. But you have the emergency managers who were appointed by the Democratic administration. They had their issues. You have the emergency managers that were appointed by the Republican administration. They're currently being sued, but not the ones appointed by the Democrats, because the Democrats are of the party who are suing. I mean, so all sorts of political problems. So you have the elected politicians. Are they going to be representing school district views, interests? So you have nobody who's an educator who's at this table.
But to laser focused, if you intervene,
You're a party.
you are a party, and you are basically saying, I am intervening because I have a right to be in this lawsuit because it could impact us. So yes, you become a party to the lawsuit.
Okay, I'm going to bring it back over here because I know that you had kind of turned it to her
Right.
previously about where we're at as far as the intervening part, so I'll bring it back to Kathy.
Thank you.
I was just going to say that in addition to AMSD, who had it as a presentation, superintendents in the suburbs and in Minneapolis, and I think conversations with St. Paul, have been meeting to talk about the why. Why would we intervene? Do we need to be? And there's been a lot of discussion about that. In addition, it is, if we intervene, what would be our common voice? What would be our solutions? And then what is the financial? What would be the financial burden, and would it be equitable among the districts, or how would that be divided up? And so when you ask that question, that's the kind of work that superintendents are pulling together so that they can discuss with their boards. And as Paula said, some of that would be done in private session if you're depending upon what road you're going to go down. So that is where we are at. Tonight was meant to be more of a foundational, here's the history, here's the piece. And to see just what the backstory is to all of this. There was one other thing I was wondering. There's been a lot of talk about intervening, but there's
Yes.
also been, there's do nothing, there's intervene, or there's monitor. Does somebody just want to just address what monitor might look like?
Sure. So, and there's also different tracks, right? I mean, so we've been discussing the litigation side of this, but there's also the educational approach to this, which is, convening to have this conversation about creating some solutions and being able to bring solutions to the table, even if you're not a party. You know, is there an access point, and having that conversation as well. Monitoring is just having, you know, attorneys or consultants monitor this case. Now, it doesn't mean you're privy to the conversations and to the court, but you can monitor the timeline and the actions of the case. Similar to what we're doing right now. Nell and I will go listen to oral arguments, we'll read the pleadings, we'll, you know, keep you up on the history, where we are with the timeline. That's more monitoring the case to keep you up to date. Intervention is just one option, and the other option is, like you said, you know what? We're not going to do anything about this. We're going to let this play out, and we're going to see where this goes. And that's always an option as well. So it's not for us to tell you what to do as much as it is to just show you what that landscape looks like.
Thank you for that clarification. Does anybody else have?
And isn't another option to just file an amicus brief with the court explaining our position?
You could. Again, it's the timing of when you would file that, and if there is a
Well-
space for you to kind of file that. I mean, it might not.
Right.
Might not be
First of
even an
all,
option.
you have to, the court has to allow you to file an amicus brief, and generally, when you file an amicus brief, you've done monitoring, because you have to know what's going on in the case, you have to know what all the arguments are, you have to know what all the pleadings are, you have to have your position established as to what it is that you are, as a friend of the court, you're helping them understand.
Yeah, you have to be, basically, you ask and you have to be invited to be able to kind of file an amicus brief.
But I think Paula's point about, you know, you have to have these conversations, as Superintendent Kelly mentioned, are going on now. You have to have these conversations and figure out what your position is before you file an amicus brief as a friend of the court, telling the judge, as a group of school districts or as one school district, or, you know, here's what we think the issues are, and we think you need to understand this is how it works.
Okay. And you've been extremely generous with your time tonight. And as Superintendent Kelly said, it's kind of the idea tonight is we all are on the same page. We understand some of the history that got us to where we're at. We have a general understanding of where they're at with this particular case. I'm not closing the door to questions, but maybe looking to try and wrap up just a little bit so we're not keeping you here all night along with us. So.
Yeah, we're fine. I just really, I appreciate the fact that you want to understand, and you want the foundation, and you want to understand the history. It is so important, even if you aren't involved, that you understand what's happening to the kids in Minnesota and what the state basically is facing right now.
Well, it was important for us, for you to be here as well. We've had a conversation or two about this and not having a clear understanding of where it's going. It's, you know, we have people that are ready to run to the courthouse and, you know, intervene immediately. And, you know, so we're kind of working to come to the same spot together. So I think it's been beneficial. And I do want to ask if anybody else has questions for you guys.
Thank you for the information.
Thanks for your time.
Yeah,
Yeah,
thank
you
you
are
very
welcome.
much.
Thank you so much, Paula.
You're welcome.
Have a great night.
Do that.
Okay, next up on the agenda will be the vision card, ECFE and ECSE, and we've got Kristen and Nicole coming to the table.
We'll get out of here.
If you guys can help me get this, do you know how to get this out of the computer? Escape? Ah, thank you.
Thank you again for coming tonight. It was greatly appreciated.
Thank you.
Superintendent Kelly, Chair Larkin, members of the board, thank you for inviting Director Stunkel and I here this evening to present our vision card for early childhood family education and early childhood special education.
We like to remind ourselves of the mission. Columbia Heights Public Schools creates worlds of opportunity for every learner in partnership with supportive small-town communities by challenging all to discover their talents, unleash their potential, and develop tools for lifelong success. And this evening, as we like to say, we're speaking about our youngest scholars in the district.
And some of the core values we'll be addressing this evening are community, excellence, and collaboration.
On this slide, we look at our enrollment. And what I'd like to point out is that where you see the red line, that is our pre-K program. That's pre-K 3 and pre-K 4. And with that, what we're happy about is that we have stabilized in terms of people enrolling and staying in our program. So we have a certain capacity. All of our classes are at capacity. When our numbers are higher, it means that we're having more turnover. So we currently, all of our programming, our pre-K 4 programming, which takes place at our 3 elementaries. We have a morning program and an afternoon program. Those are all full. And then here in the Family Center, we have our pre-K 3 program. This year we have 3 of those classes. They meet twice a week. And then the 4th class is an ECFE model. I wanted to just mention with this that this is a full inclusion model where almost a fourth of the students in our pre-K program are also being served through early childhood special education. Would you like to add anything?
that's
Okay.
okay.
And then with ECFE, that's our early childhood family education program, and that's where parents come with their children. With early childhood screening, all children must be screened within 30 days of entering kindergarten. Now, this doesn't mean that they can attend kindergarten. If they're 5 by September 1st, they can attend kindergarten. What we're really aiming to do is to have the children screened at the age of 3. And the reason why we want to do the screening at 3 is because then if there are any interventions, hearing, vision, developmental, we're able to do that intervention to provide them with the services prior to starting kindergarten. Finding out that they need those services to be ready for kindergarten 2 weeks before kindergarten starts is not as effective as learning about that a year or 2 ahead. This is our strategic roadmap, and I believe that we sent this to you also, but this is our scorecard. We've been able to maintain at the level 5 for all of our sections, and that regards all of our curriculum being aligned from early childhood family education through 3-year-old, 4-year-old program into kindergarten, that all of our licensed staff are involved with the PLCs. For our early childhood, our ECFE and pre-K staff, for 3 years now, their focus for their PLC has been on equity. Do you want to add anything? Okay, I'll just keep talking then. Very good. And then we have very strong teachers who are using data. They are looking at their assessment that they do in our pre-K 3 program twice a year, in our pre-K 4 program 3 times a year. They're identifying how the students are doing. They're adjusting their instruction in order to support that, expediting in the areas where the students are doing well.
And just adding that all of our early childhood programs, early child special ed and family ed, follow the state standards for all their curriculum and assessment.
The early childhood indicators of progress, that's what we use for basing our curriculum. Do you want to talk about the interventions?
So as Kristen said, our programs are one of the first in the metropolitan in the state. For many years, we've had full inclusion, if appropriate, for students, collaboratively working together. Some students don't need collaborative work or an educational assistant with them, but they'll need some interventions. And so when they're talking about the groups that get together, the teachers that get together in the PLCs, they talk about what interventions work for kids and how to utilize them in all of the settings in early childhood.
The one area where we're still trying to make some headway is with screening children at the age of 3. And this is a public perception challenge. A lot of parents want their children to hold off until they're a little bit older so that they'll do better on screening, thinking that it's a test that they ought to do better on. And so I just wanted to take this moment while we're on the screen to be able to say that it's really important that children come at the age of 3 during that 3-year-old year to do the screening, that it's adjusted for their score is adjusted based on how old they are. And so we really encourage parents to bring their children at the age of 3 for screening. our early childhood programs, ECFE, pre-K, home visits, which we are able to do for any family in the district, birth to 5 years of age, early childhood screening we've already talked about. Super Saturdays continue. Family Center Presents covers a variety of themes. Early childhood special education, and then early literacy training for parents, and I believe that that's in the early childhood special ed program.
Yeah. It's been fun. I've been doing some home visits with our early childhood special ed families for the birth to 2-year-olds, and it just, it's really enjoyable to get out into the homes and visit with the parents as well as see what the teachers are doing with their kids.
Yes. Our Pre-K3 and Pre-K4 program, as well as our Mini Adventures program, are 4-star Parent Aware. 4 stars is the highest rating. We're so pleased to be able to be in all of the elementaries. We're pleased to be able to work with teaching and learning in the age 3 to grade 3 task force for that alignment. And then we're very excited that the Columbia Heights Library, the new library, is going to be opening at the end of June. We have 3 collaborations there, a Baby Read, Baby Grow. Last year we added a toddler story time, and next year we'll be adding a preschool story time. And that's co-taught between our staff, our early childhood family education staff, and the library. Our goals are to continue to work on the assessment alignment. And the one area that we're just waiting on MDE for is that early childhood indicators of progress section on math. Until we get their revisions, which they are actively working on, we're not going to be changing our assessments until we've got that revision, because then we'd have to redo it. They hope that by the end of the summer they'll have that done.
Questions?
Questions or comments for these guys?
I just have one thing that I want to get clarification on is, are you a part of the Help Me Grow referral process?
Yes.
For the 3-year-old screenings?
Yes, we are.
Okay.
Anoka County, what Director Lewis is referring to is Anoka County has a helpline. It's a program that the county does to encourage families to get in screening even prior to 3 other screenings through their physicians. They can call the county helpline. They then contact us by phone, I'm the contact, and say we have a family that has contacted us or a doctor has contacted on behalf of the family. And then we get our early childhood teachers to contact them and see if we need to move forward for assessment. It's worked out very well. We've been involved with them from the beginning.
Wonderful. So that would be one option. Otherwise, how would parents or other people go ahead or go about referring a child for that screening at 3 years old?
Sure. So calling our community ed office is the way to get signed up for screening starting at 3. And we also have information about this in our community ed brochure that goes out to all households in the district. On our website, on the school district's website under early childhood education, we have a number of community resources, including Help Me Grow and access for all of other county supports, as well as also a lot of information on MDE's website for early childhood.
As well as Victoria Campaverde has a group of Spanish-speaking parents that she meets with, and the liaisons that are in the elementaries do outreach to our Spanish-speaking families to encourage them to come earlier.
I'm glad to hear that. Thank you.
Anybody else? Ted?
Have we measured what percentage of students are actually kindergarten ready after the preschool programs?
Yes, we have been starting to look at that, and now with having the students have MARS numbers, it's easier. In the previous years, we didn't give them the student numbers. That is a recent change that we're allowed to do that, and that's enabling us to follow, to track how they're doing, and we'll be able to then track them going forward as well.
Okay, I think that'd be very interesting data to present and to follow. I'm glad you're including the parents and creating homes that are educational and friendly to that. That's great.
Yeah.
Parents are the children's first teacher.
Yes.
Bill? Thank you.
Thank you.
Thank you.
Next up is Community Education Adventure Club, Mini Adventure Club fees. Bill and Krista.
Chair Larkin, members of the school board, Superintendent Kelly. Director Holmgren and I come this evening to speak with you about increasing the Adventure Club Mini Adventures fees starting with the new school year. Our mission continues throughout our Adventure Club and Mini Adventures program, and I'll just remind you that both of those programs are our child care programs for our district. Community is certainly one of the core values, collaboration, integrity in terms of especially financial integrity, and innovation in terms of our programming are parts of our Adventure Club and Mini Adventures program. So the Mini Adventures preschool program that takes place here at the Family Center, this is a 6 a.m. to 6 p.m. program, and we have different fee options depending on if the children are coming 1, 2, 3, 4, or 5 days a week. I just wanted to mention at this point that Adventure Club and Mini Adventures must be self-sufficient. Their fees must cover their costs. So we're not able to use Community Ed Fund to supplement those programs. So our fees are entirely based on what the program costs to run. And because perhaps Director Holmgren would like to speak to this, some of our costs increase each year. We need to, in the same way, adjust our fees.
Yeah, every year, as you know, our labor costs slowly creep up. And when we're looking at the changes, we're not talking about huge changes in our fees. It's just enough to cover our increase in our labor costs going forward to make sure that that particular program balances at the end of the year.
So you'll notice that it's not a significant increase. All of these increases are between 2.5% and 3% this year. And but that is reflective of the costs of the program going up between 2.5% and 3%. For Adventure Club, it's the same situation where it needs to be able to cover its cost. What we're looking at is a 50-cent increase per day for the after-school program and for the drop-in. And then there is a slightly greater increase for the school release day and the summer full-day program from $33 a day to $35 a day. I will mention that a neighboring district for a comparable school release or full-day program is $45 a day. So we are still well below some of our neighboring districts in terms of the fees. The fees do include meals for Mini Adventures, that's breakfast and lunch. During the summer, that's breakfast and lunch, and then for both of the programs, snacks. Field trip costs are included. The curriculum and program supervision by a licensed teacher who is Jody Gadient. She's our manager. Our Mini Adventures is 4-star parent aware. There are a variety of activities, and then I also have been working with Manager Gadient and also our early childhood manager, Karen Kramer, to make sure that the work that's happening in our age 3 to grade 3 task force is rolling over also to our Mini Adventures program so that we know that students that are participating in the Mini Adventures program are also ready for kindergarten. For families that need fee assistance, they've got a couple of options. One is the Pathways 1 scholarships. Those are those scholarships that go directly to the students for paying for programming costs. Another is with the CCAP program, that's the Child Care Assistance Program. And Jody Gadient works very closely with families and also with the county for those fee assistance programs.
I'm new to this. Is this fee increase in the typical range?
Yes, so last year it was a 5% increase, and this year, in meeting with Director Holmgren, because the costs for staffing have gone up about 2.5% to 3%, that's what that reflects. There's no increase in the supply budget. In fact, our supply budget hasn't increased in about 10 years. So, yeah. So really what we do is we look at how much does the program cost, and the program costs what it costs based on the ratio of adults to children, and then we go from there. Is that accurate?
Yeah, that's accurate. I think one thing to point out too is before last year's increase, there was actually quite a few years that we didn't have an increase, and we really were running into trouble with not having enough money to run the program. So that's why you're seeing a little bit increase now.
I'm assuming the ratio of adults to children is set by the state, or that's nothing we can really control? Is that
Correct.
Okay.
Yeah. That's for the quality of programming as well. And families are very, very pleased with our programming, which is terrific.
Have we had to turn away people because they weren't able to afford the fees, or have the programs made up for the fees for those who need them?
So we can't scholarship families. We have to have set fees, but then we do help them to work with the county for CCAP or with the state through Parent Aware for the Pathways One scholarship. But we don't have the capability within our budget to scholarship families directly ourselves.
Right.
So there are families where they meet with us, and if they don't qualify for CCAP and Pathways One, if they're not able to afford it, then we certainly will make them connected with the county to find other licensed childcare providers. But we're not able, in contrast to our early childhood family education program, where we can adjust the fees, with the childcare program, we cannot adjust the fees because we didn't build into our profit margin space to scholarship. Does that make sense?
Right, so do you know, are there many families who haven't qualified for county assistance that have had to go elsewhere?
Yes.
Okay.
Yeah, and that's always the case. The parents are going to need to make decisions based on what they can afford, and some choose in-home childcare or family friend and neighbor as well.
Okay.
Anyone else? Okay, that answered my question anyway. Then I was going to, for the record, this is not a money-making business that we have going on with our child care program. So.
Not at all.
Not at all.
And I knew that, but.
The rates are pretty similar to adjacent districts.
Yes, lower, but yes.
Lower, yes, yeah. So, yeah.
We really want this to be available for our families, but we do have to cover our costs.
Okay. Anybody else? Thank you.
Thank you. Then this will come forward at a future date as an action item.
Yep.
Thank you very much.
Thank you. Next up would be our overnight and out-of-state field trips. Host of people come on.
Chair Larkin, members of the board, Superintendent Kelly, we are here this evening to present you with information on overnight and out-of-state field trips. I am pleased to have Principal Robleski and Principal Burkus presenting with me this evening. So as always, our mission is to create worlds of opportunity for every learner. And this presentation will focus on excellence and collaboration. So our first proposal entails 8th grade Spanish. So I'm going to ask Principal Burkus if he'd like to talk to this.
Sure. Thank you. Yeah, as you know, the Concordia Language Village trip is now, I believe, in its 3rd year. We've had some great trips up there and would love to be able to do it again. Just talking to Marie Nelson again today, our Spanish teacher at the middle school, and she said the big thing she notices, in addition to just how much fun it is for kids, is when they get back, how much more Spanish she hears kids using in the classroom. They're used to now just conversing in it. So she sees very tangible results right away from it. So they go and they do all these great things. They do it all in Spanish, and they come back tired, but I think really pleased that they went on the journeys. So next year, if you'd like me to continue, we will propose then to you to go again in March, as we did this year, and that we would go with our Spanish 1 8th grade students, and we would again try to give them that opportunity to be immersed in Spanish. And they do a great job there. We've seen it many times, and we'd love to go back. Fundraising, they have done a great job with this. Ms. Nelson really pushes them on this. They sell calendars, tickets for meat raffles. They do sales at the basketball games and the musical. So they do work hard on this. I know that the boosters have been very kind and generous to them as well, as have been some other organizations, but they do work hard. And this, you can see the proud Spanish speakers there that went this year. So it's a nice-sized group, and I think is one of those activities at 8th grade that's ideal for our kids to be participating in, to encourage them to stick with it and go on to high school and continue to learn Spanish.
And if I may add, I had a personal experience as a child being able to attend this same Spanish camp, and it really has had a lifelong impact on my bilingual abilities and my life. So I'm really pleased that we've been able to offer this opportunity to our 8th grade students. Our next proposal is we're going to look at the previous year's proposal for a rotating field trip and college seminar trip to New York City. So we're going to look at last year's, and then we're going to look at our newest proposal. So Principal Robleski.
Chair Larkin, Superintendent Kelly, members of the board, good evening. Excuse me. As you can see, in 2015, we had a high school proposal of a rotation on our work seminar trip to New York City.
So then this year?
So as you know, as you experienced for the first time, we've made some adjustments to our rotation. And I think our students came before, after the trip, and really made a case before the school board and the Booster Club and other entities that supported our trip, our work seminar, is that with our AP Art students, they were able to apply what they learned in the classroom out into the museums and structures out in New York City, and it was the investment really the investment paid off with a lot of our students doing the AP art exams. And so what we've looked at is looking at our students. They're on a 2-year cycle to get to the AP level, to the AP courses. So usually it's a 2-year cycle before they take the test. And so we've implemented with a change of having our AP art students coming every other year.
In addition, other field trips and other out of overnight excursions are an extension of what we were able to do this year over spring break, the 3-day where the students went to Mankato and to Duluth. So it's a combination of a college visit and also a cultural experience linked to our academic standards, and then historical pieces where students are able to really discover out in the field, that hands-on opportunity, and then getting to see, take a college tour. And it's really, we have found, and research will show how important it is for kids to get out onto a college campus to see what it has to offer, have the questions answered, and of course, eat in the dining halls, right? It's their favorite part. So we're proposing a similar experience for students next year. The next, this has been mentioned earlier in the school board meeting, but the All-America City Award, we wanted to make sure to include this as an information item. Our high school Dynamics Choir has been invited to attend the city group as one of the nominations or nominees for becoming an All-America City. Again, the dates would be departing June 16th and returning on June 20th, heading over to Denver, Colorado. Fundraising, I have my raffle ticket, so if you haven't gotten yours yet, you can get them at the Public Safety Building, or from our school board chair, I would imagine. Fundraising is happening.
As a firefighter, as an assistant fire chief, I do have them available, yes.
Thank you. And then again, noodles. So we're very excited about this opportunity with the students. And that concludes our what we have on the roster for overnight and out-of-state field trips for next school year.
Laura?
I do have a question. I noticed that band has been dropped from the rotation. Is there a reason for that?
I don't believe band has been dropped.
Or we were just looking at the choir and adding in the AP?
I think it was a typo, sorry, I apologize for that.
Oh,
It's
okay.
theater. At this point, for next school year, theater, because we don't have an during the school day class, and it's an after-school activity, yet we do have AP art during the school day, that we would be looking at next school year for the New York trip to be the choir and then the AP art students.
And then in 2 years, the band would be going.
Right. I think that was what you proposed in 15 was.
That's what I
Band,
remembered. That's why when I saw it, I was just like, okay.
Yep, typo, sorry. I'll fix that before it goes out.
Now, I know you're bringing this forward as information, obviously, but what will be our role moving forward with these things? What will we be looking for from us? As far as approval, I mean, is it coming to a meeting sometime soon?
Yep,
or-
so at the next school board meeting, we'll be bringing forward at this information as an action item for approval for out-of-state travel and overnight travel.
Anybody else have any questions about any of this?
So I'm assuming that the decision to go back to New York City for the choir and art is just because of the resources there, that it's the best city to go to? Is that the thinking, or?
Well, I think we do have a number of contacts
Okay.
that make that trip a once-in-a-lifetime trip, that we have contacts out in New York City that other schools and other people don't have access to. For example, last year when we went to Wicked, we were able to secure a talk-back session afterwards with, I believe, the lead. I can't remember if other people were, I know there's a number of us who were there. I can't remember. There was the head of makeup, costumes.
Head of the band. We tailored that so that they
Correct.
could have experiences. Since we had the band out there, we had members of the band, like the first chair and the director of their orchestra is what they call it out there. And so we also had, then the band was able to study with a symphony director, so that it's tailored. But as long as I'm talking about it, we also went on a number of college visits.
Yes.
And it's a seminar, it's not just a performance, it's for them to grow in their art form, but also in the academics to see what is out there. And we had a wonderful offer from the College Board while they were out, and the offer of this was, the next time we come, they would like to host us at their building and bring in some of the colleges and do some seminars for us as well. So that's an add-on. So we're thinking the more we do something like this, the more we will grow the network and let kids get a taste of East Coast resources.
Okay, makes sense, thank you.
I think we also have a contact with a very great program called LEADA, that a number of students, Louis Carchi has participated in, is attending Princeton. We have, I believe, at least one finalist with the LEADA program as well this year, and we have made contacts out there and made visits to their building as well.
Just as an information item, I've been fortunate enough to have as a parent, one of my kids go on the New York trip, and you call it a once-in-a-lifetime trip, and truly, based on the itinerary and the things that he came back and shared, it truly was. And then my daughter also was at the Spanish immersion camp this year, and she did come back and say that she actually, even going in, knew more Spanish than she thought she did, and came back and was even better able to speak it. So I see personally, as a parent, I've seen benefits from at least those two programs. So I like in the Chicago trip that the choir just did too. It wasn't just run to Chicago and hang out for a weekend. The kids there was something structured and productive educationally or performance-wise all the way through. So my belief is if that's the approach you take moving forward with these programs, that they'll be well-suited for the kids. May also have questions or comments?
I just have one quick question. The trip to New York City, can you talk about the opportunity for all students to be able to attend? Is there plenty of fundraising opportunities, things like that?
Yeah, we have a number of fundraising activities. Our the staff as well across the district participated in fundraising activities. There's plant sales, there's calendar sales, a number of activities that they do as well as fundraising. And, you know, the support of our Booster Club as well has been fantastic.
So is it fair to say that most of the children will have, if they're in these designated groups, that they have the opportunity to go?
Yes.
Money is not going to be a factor.
Well, money is always a factor.
Okay.
I'm just going to say that, but
Yep.
not just for the students, but for the school district, because
Sure.
it is a big sizable chunk of change. And I know sometimes people say, why don't we take them all at once? And it's because money is such a sizable uphill battle for us. As soon as we bring you the governance question, if you approve these trips, we will start a planning and fundraising committee that students will be able to both earn money individually and put in their own accounts, and then work at, toward group things as well. If there's a need, there'll be a process, but we really prefer to have kids have skin in the game and to really help us work toward, because money is an issue for us on any trip we take.
Well, and I think I would like to point out one thing is that a lot of trips are planned through agencies, and this trip is planned in-house. And the amount of money that is saved and the experience that our kids get supersedes anything that I've been part of in my educational career. So dollar cost, I would find it hard to believe that you would get more, bang for your buck with something that we put on here at Columbia Heights as a work session, as a college visit, as an overall experience. But Superintendent Kelly, you are right, money is an issue, and I think pointing out that we need to start fundraising yesterday is apparent. And I think the rotation that we have set up kind of speaks to the volume of cost and trying to make sure we have all opportunities for all students.
I'm just curious, how much Spanish do the Columbia Academy students have before they go to the Concordia language camp?
These are mostly level 1 Spanish students, so that starts in 8th grade, so they have about, they start in September, and they're leaving in March, so.
And do we
they have
track
about
if they
7 months.
continue on in high school after the camp, or?
About after the camp, I
Yeah.
think a lot of our students do carry on with Spanish at the high school. They certainly come back enthusiastic to finish up the school year. It can get tough when you're at level 1 because you're not able to say even some basic kinds of things, and so it can get, at times, you want to just switch back into your own language. So I think it's key to encourage kids when they're at those stages of not giving up, but sticking with it. And I think this energizes them, gets them through the spring, and helps them feel successful, that they can do it. So I think it's a good motivator for them. Keep going.
Yeah, it'd be interesting to see how many actually go on to take Spanish at the high school. But I see a lot of value in this anyway. Thanks.
Anybody else? Thank you. We'll move on to our action items. First up is board policies. It's a second reading for 707, which is transportation of public school students, 805 waste reduction recycling, 807 health and safety, 808 water safety. These policies appeared in the April 26th meeting for first reading, and approval is being sought for tonight's meetings. I know a question that often comes up, Superintendent Kelly, is, has there been anybody that's reached out and asked questions or had concerns since this has been made available?
Not through the superintendent's office.
Okay. Start with a motion to move this forward.
So moved.
Laura, a second, please.
Second.
Natty?
Mm-hmm.
Thanks, Natty. Discussion.
I had a question on the water safety policy. What's the genesis of this policy? And it seems like there are a lot of procedural parts to this policy. Is this something that we need to address as a school board because of the procedural aspects?
The genesis of this policy really relates to the fact that we have a pool.
Okay.
And in recent history in a neighboring district, there was a death in a pool. And people started looking at where were the pool policies, and they didn't exist. So we've always had procedures, but we wanted to codify that we also had some governance structure in place in the form of policies on how we address water safety in this district. So we started with the neighboring district that was actually spending a year in litigation to see what their water safety policy would be. And then contacted MSBA, and they did not have one. And so we worked with our attorney with the insurers. We looked at and formulated a lot of different procedures that we wanted to codify and came up with this water safety policy, because we want to make sure that not only do we have the pool, but we have the appropriate instructors in the pool, the appropriate class size, because it's a matter of life and death. And having said that, we also know that Minneapolis has publicized it quite a bit, that we live in the land of over 10,000 lakes, but we have many, many kids who don't know how to swim, that they're perhaps immigrants, or just don't have access to a lake cabin, to a pool. And we have many students who have either poor experiences with swimming, or actually there's tragedies that go and kids die in the summer because they don't have it. So we just wanted to make sure we had a foundational base for this. And so we've worked on this, I think, for probably 18 months to come up with this, and we've vetted it through everybody, so we feel it's what's in there really needs to be in there for a liability, for child safety, codifying licensure, and just making sure that we're following best practices in water safety.
So it was recommended by legal counsel and our advisors to have all of these provisions
Yes,
in our
indeed, and as
policy.
a matter of fact, we even ran it through our insurance company for liability issues as well. So
Okay.
and they ran it through their attorneys, so we looked at everything.
Okay, thank you.
Yeah, I was going to say, one of the things that I really liked in this policy was it specified that whoever was supposed to be watching the children while they were in the pool was not allowed to do anything but watch the children in the other pool. And, you know, they weren't allowed to do any other type of job or have any other type of responsibility. So that's actually written in the policy, and, you know, they can't be asked to help with anything else. Their responsibility is to guard those kids. You know, so I like this, and we needed to do this. I mean, from that moment of that tragedy, I know we were talking about it right away.
Okay, anyone else?
Just to comment that when we have typically when you have such a specific policy, it's important to follow it. And having a policy is great, but if it's not followed, that can lead to even greater liability. So just a comment.
And I would have a follow-up. It's an and, we agree. And that is why we have special trainings for all of our teachers to get certified. And we are looking to our students as well, and this is the first year that we had one of our swimmers go all the way through the water safety training and a lifeguard training, and so he helped out as well with our classes. And I do know that teaching and learning, as well as Columbia Academy, have been ever vigilant following this before and now, because we really want to avoid tragedy and support our students in their learning in this area. So it's a policy that has been read, reread, and put into practice.
Okay.
Anyone else? Okay. Hearing no further discussion. All those in favor say aye.
Aye.
Opposed? Abstain? Motion carries. Next up would be the performance studio space bids. Back to Holmgren's and Henneken.
Chair Larkin, members of the board, Superintendent Kelly. Last meeting, we showed you some plans of what we're planning to do for performance studio for the high school. Tonight, I bring forward the bids, and you can see that we had 5 bids. I'm very pleased when we get more than a couple bids, so we get a true cross-section and we get a, really a pretty good price usually. So I'm very pleased with what came forward. You can see there's a pretty good range from 271 all the way up to 363. We're very pleased that Rack Construction is our lowest bidder. We have used them for many smaller projects in our district over the last few years, so we're very comfortable working with them on this project. So tonight, we just like you to go ahead and take action, and we'll award the performance studio bids to Rack Construction.
Okay, could I get a motion to move that forward, please?
So moved.
Is that Molly?
Yes.
Second?
Second?
Ted? Thank you. Discussion?
Is this within our budgets?
Yeah, actually, as we were working through this, I kept getting more nervous as we went forward, but this comes right in where we put the budget, so I'm very pleased with that also.
Any other questions or comments? Hearing no further discussion, all those in favor say aye.
Aye.
Opposed? Abstain? Motion carries.
Thank you.
Thank you. Next up is discontinuance or reduction of programs and positions. Lindsay.
Chair Larkin, members of the board, Superintendent Kelly, both Director Holmgren and myself were here at the last work session to discuss some preliminary staffing. Administrators have been meeting for a couple months now to go through staffing per building and district center. And tonight you'll be seeing 3 resolutions. The first one is the discontinuance of educational programs and positions for 2016-2017. So tonight we're here seeking approval of this resolution.
Can I get a motion to move that forward, please?
So moved.
Laura, second.
Second.
Molly, thank you. I'll read the resolution, then we can have discussion. Resolution discontinuing and reducing educational programs and positions due to enrollment and departmental efficiencies. Whereas the School Board of Independent School District Number 13 adopted on February 12, 2016, directing the administration to make recommendations for reductions in programs and positions. Whereas said recommendations have been received and considered by the school board, be it resolved by the School Board of Independent School District 13 as follows. The following programs and positions or portions thereof be discontinued due to enrollment, program elimination, curricular changes, and departmental efficiencies. Be 5.8126 net FTE licensed and non-licensed elementary positions, 4.21 net FTE licensed and non-licensed Columbia Academy positions, 3.3775 net FTE licensed and non-licensed Columbia Heights High School positions, 0.5 FTE non-licensed Human Resource Department positions, 1 FTE non-licensed Finance and Operation Department positions, Student Services Cultural Liaison position reduction of 10 work days, all teacher positions with licensure variances by law or need to renew, all teacher positions that were one-year contract, long-term substitute positions, and all positions cut for performance. Discussion.
I'm just curious, has anyone, other than what has been presented by the superintendent at our work session, have we looked into this independently, other than based on that information? Anybody on the board? I haven't.
Independently, I don't know what you mean.
Received other information other than what we received at the work session. Did research, independent research.
No, I have not.
Okay.
And you said you had not as well?
I had not. Anybody else?
I have not.
Okay.
Any other discussion?
Just a statement is because I haven't, and I feel that we have an obligation to look into this as the school board as the governing body responsible for the care management and control of the district. I'll have to abstain on this vote because I don't feel like I can make an informed vote on these positions.
Just a follow-up question to that. How long have you known that this was coming? I believe it said January 12th is when it was brought to the board. I mean, I chose not to independently research it because I have confidence in staff and administration to make the decisions that are necessary to be fiscally responsible for the budget of our school district. I'm just curious as to the choice of abstaining the night that the resolution comes forward based on the lack of independently researching it with knowledge of it taking place as of January 12th?
Well, first of all, I don't think that question is quite relevant, but when I knew this was coming forward. But the information was presented to us, I believe, at the work session, our last work session, not January 12th, as to what positions were actually being, the specifics. So I've known it since our last work session.
But you knew it was taking place since January 12th. You knew that we gave the administration the approval to make the recommendations.
Right, but that's, I don't see, what's the relevance of that?
Did you vote in favor of that, approving, giving the district permission to move ahead?
I voted for the resolution, which says that we are asking the district to make recommendations. And my understanding, these are just recommendations. Is that correct, Superintendent Kelly?
The governance, in my opinion, the governance permission for administration to do the work of management was the January resolution.
Okay.
And then the administration spends probably 2 to 3 months going through what the board has decreed in the governance of making efficiencies to programs and to positions, and also to go through the staffing process for performance that leads either to tenure or not. So those are all the work of management. And so when the recommendations come back, they're aligned to the governance resolution that you passed, saying make the efficiencies. And then we have put together the recommendations based on that work. They are recommendations from administration, and some of them are covered with data privacy as far as positions that are cut for performance and things like that. So there probably would not be independent research into those areas. I think at work study, if there were questions on why a particular position needed to be cut, staff would have been willing to answer those questions. But I do feel that this is aligned with the governance that the governance resolution that you put forward in January, as we have done routinely in this district every January since I have been here since 1998.
Any other discussion regarding this resolution? Laura?
Can I add one more thing here? I mean, we do this every single year, and as I always understand it, I mean, we instruct the administration to look carefully at where our needs are and to make sure that we're staffed appropriately. Those decisions have to, by law, be, if you do decide you're going to have to give notice that you're not going to renew a contract, by law, we have to give them as much notice as possible so that they can find other options, last minute, right before the school starts and you find out that you don't have as many kindergartners as you thought you were going to have. So often you will see a lot of, from what I've always seen every year, is you seem to lose a lot of more positions at the elementary level because you don't know how many kids are going to be coming to the door. That those are often, it looks like they get hired back pretty quickly so we can get up to staffing. So we do this every year. There is not actually that many positions that are being trimmed back, and I think that goes to the hard work and keeping things in budget and making sure that we're the right size all the time. And I do appreciate all the work that goes into it. It's a lot of work. Thank you.
Anyone else? Any questions?
Just briefly, I want to comment and just make a statement kind of on the record, I guess, that when we did receive this information, I feel like at any point, if I needed clarification, I could have gotten that. But kind of along with what you said, Chair Larkin, is that my understanding is that we gave permission, and as hard as it is to make cuts and everything like that, they do affect people, but it's needed, and I've understood this process, so I haven't had any questions. I just want to clarify that, and if I had, I feel like I could have had them answered.
Thank you. Anyone else?
My question is if we gave authority to the superintendent to make these cuts back in January 12th, 2016, then why are we voting on this again? If that's what the resolution, I don't believe that's the resolution was back then. It was to present these recommendations to us for our consideration. Mm-hmm. And I'm concerned, I've brought this up before with boards that, as Superintendent Kelly mentioned, there are data privacy issues that we've been informed of by our school district attorney, where this board actually couldn't take independent research into these positions and obtain the information necessary to make an informed vote. So it's a problem with the process, I believe, and I'm just, we all have to act independently of our own, based on our own decisions, and I'm just making a comment so that the community knows what's been happening.
So noted. And I guess I would echo a bit of what the superintendent said, which is our role is governance, and we did give them, if I'm reading it correctly, in January 12th, we directed the administration to make recommendations for reductions in programs and positions, and that's what they're doing tonight. And I don't see it as my role is to sit down and go through and say, we need to get rid of 3 kindergarten teachers or this many staff at Columbia Academy. That's why we have administration. That's why we have a superintendent. That's my statement and my belief. Sure. And I don't feel that there was ever a need for me to do any kind of an independent study of whether or not our human resource director is making the right decisions, combined with the finance director, who is extremely aware of what our budget is and extremely aware of where we're at in regards to where we want our budget to be. So that's my point.
And one last point I'd like to make is, we talk about governance, but that's not really what the statute says for this role of the school board. The role of the school board is the care, management, and control of the school district. That's why we hire a superintendent to do that. But we are ultimately responsible under Minnesota state law for the control, management, and control of the school district. So given that, that's why I feel the need to understand actually what's happening with these cuts and reductions. And I don't feel like I can do that based on what we received.
So noted. Anyone else?
I just have a quick question here. Okay, when you're making the analysis due to budgets and forecasts and enrollment and everything, how many hours goes into this to be able to have an adequate picture, even if you're just looking, do you look at it by the school, each individual school, or each individual grade?
We have many meetings, and I don't even know if I could give you a count of how much time is spent. We'll schedule 1 to 3, and we'll be there till 5 o'clock at night. We do look at every building individually. We look at them collectively. We'll meet initially, we'll come back and meet again. Bill runs the numbers, and we'll see where we're at, and we'll come back and look at it again. We'll meet, the entire district, so all the principals and directors sitting around the table. So I couldn't give you a total amount, because even if I looked back at what we have scheduled,
I didn't think you could.
it goes well beyond what we have scheduled for the time.
Because I see some very specific numbers here, and this is 5.8126. That seems pretty specific.
Yeah. Anybody else have any questions or comments regarding this resolution? Hearing none. Ted, if you would please read the roll.
Asmari.
You would say, aye or nay.
Aye.
Severson.
Aye.
Lewis.
Aye.
Larkin.
Aye.
Palmer.
Aye.
Landwehr abstain.
It's always tricky with these
Passes,
corporate votes versus individual votes. We'll get it.
All right, the motion passes. Next.
Chair Larkin, members of the board, Superintendent Kelly, the second resolution tonight, this is the non-renewal of teacher contracts, and by law, we do have to do this. Staff list on here, some are cut because they're an LTS, which is a long-term substitute, which we by law have to do. Some are on a variance this year, which is only good until the end of June. Other staff are performance cut, and some staff are cut just because we do not have a position in the family at this time. As the year goes on, maybe we add positions back, we might be able to hire some of the staff that are not cut for performance back into the family. So tonight we are seeking approval of the resolution to terminate and non-renew the employment contracts of these probationary teachers.
Motion to move that forward, please.
So moved.
Laura?
Second.
Natty, thank you. I'll read the resolution. Resolution relating to the termination of non-renewal of the teaching contracts of probationary teachers, whereas the following persons are probationary teachers in Independent School District number 13. Be it resolved by the School Board of Independent School District Number 13 that pursuant to Minnesota Statutes 122A.40, Subdivision 5, the teaching contracts of those persons listed in this resolution, probationary teachers in the Independent School District Number 13, are hereby terminated and not renewed at the close of the current 2015-2016 school year. Be it further resolved that written notice be sent to said teachers regarding termination and non-renewal of his or her contract as provided by law, and that said notice shall be in substantially the following form. Notice of termination and non-renewal, name so stated in this resolution. You're hereby notified that at a regular school board meeting, at a regular meeting of the School Board of Independent School District Number 13 held on May 10th, 2016, a resolution was adopted to terminate your contract effective at the end of the school year and to not renew your contract for 2016-2017 school year. Said action of the board is taken pursuant to MS 122A.40 Subdivision 5. Discussion.
Again, I'm just saying that, want to say again that because of, for the same reasons, I'm going to abstain on this vote because of not having enough information.
I would like to have a point of personal privilege, because then I would just like to state for the record that the school district, a school board has but one employee, and that is the superintendent. And when it comes to the probationary teachers, we would never be discussing at the board level for governance why an individual teacher is going to be let go.
Okay. And in the interest of keeping this meeting moving, same comments as previously myself, so other conversation or discussion?
I have a question. Has all of these staff have been notified? Okay.
Yeah, they've all been notified, and I called all the principals and all the directors who had it notified today to make sure everybody was told before it came to the board.
Okay. I figured that. I was just going to reiterate it.
Yeah.
Thank you.
Any other
Good.
discussion or questions?
Okay.
Hearing no further discussion, Ted, please read the roll.
Ms. Mari?
Aye.
Severson?
Aye.
Lewis?
Aye.
Larkin?
Aye.
Palmer?
Aye.
Landwehr abstain.
Motion carries. Lindsay?
Chair Larkin, members of the board, Superintendent Kelly, the third resolution tonight is the termination of staff that are not licensed. This is the non-licensed staff that will not be continuing for the 16-17 school year, and they also have all been notified by their principal or director. So tonight we're seeking approval of this resolution.
Okay. Again, motion to move it forward, please.
So moved.
Laura?
Second.
Molly? Read the resolution. Resolution relating to the termination, elimination, and reduction of positions and programs. Whereas positions and programs as listed in this resolution or employees of the Independent School District Number 13, be it resolved by the School Board of Independent School District Number 13 that those persons or positions listed in this resolution in Independent School District Number 13 are hereby terminated, eliminated, or reduced at the close of the current 2015-2016 school or on the date otherwise noted. Be it further resolved that written notice be sent to said employees regarding termination and elimination. Discussion.
So I'm noticing that there are 3 people who are Check and Connect specialists. Is that program still there?
Yes, it is, but sometimes it's program dependent on funding for grants, because it is grants. So the program exists for the funding that exists currently.
Okay.
Any other questions or comments? I'll just make my annual comment about this, that this is one of the least enjoyable things that as a board I feel that we need to do. And I do recognize the need for it, but it doesn't make it any more pleasant or enjoyable. So it's a difficult thing to have to do, but I know that in the best interest of the district that we're making the right decision. So if there's no further discussion, if
I'd
you
like
would.
to add to that too, that
Yeah.
it tags on to actually what's in the Constitution that we talked about before, that we're responsible for running an efficient school district. So we have to be efficient in our uses of resources.
Okay.
Yep.
Anyone else? Hearing no further discussion. Ted, again, if you would, please read the roll.
Ms. Mari?
Aye.
Severson,
Aye.
Lewis,
Aye.
Larkin,
Aye.
Palmer,
Aye.
Landwehr, abstain.
Motion carries. Thanks, guys.
Thank you.
Thank you.
Board topics. Anybody have any for board topics?
I just want to mention, going back to the fundraiser at Noodles and Company, that I believe you need to mention that you're there supporting the fundraising for the city
That
when
is
you
a-
are ordering,
That is
so.
an accurate statement.
Yes.
Although Director Mahon has had conversations with someone at Noodles and Company, and they have agreed to that if you don't mention it, they will ask you if you are here for the fundraiser so that we can get the
Lovely.
credit. So, yes, in a perfect world, people would mention that they're here for that fundraiser, but did I say it right, Casey?
Maybe
Okay.
just a sandwich board outside and going, hey,
We had conversations about
50%
standing out.
goes to fundraiser.
Casey said he didn't want me to have to stand out there all day, so he'd make a couple calls to Noodles and Company, and I
Thank you,
appreciate that.
Casey.
I'd still like to see you standing out there.
If it's a nice day, I wouldn't mind, but just touching on the 20th fundraiser, which is at the Public Safety Building. Again, there's going to be music, there's going to be stuff that's good fun for the kids, there'll be food, bingo, raffles, a lot of different things. There will be a fee at the door. I believe it's $5 to get in, and if you want a meal or a beverage or whatever, there'll be a fee for those things. But thankfully, the majority of the things have been donated, so that whatever money we take in for the services that you're purchasing there will go towards the fundraising for the delegation. So we're looking for a really big turnout. So for both Noodles, which is coming up right away, and then the fundraiser on the 20th as well. So and that's from 6 to 10.
And that's on Thursday, the noodles?
Noodles is Thursday from 10:30 a.m. to 8 p.m.
Awesome, I don't have to cook dinner.
Did I get that right, Casey? Okay, good. And
This
again,
is a
just
good day for
touching
my
on what we
family.
talked about earlier, is if for some reason you're not able to, the timing isn't there, if you can run in and buy a gift card, again, mention the fundraiser, $25 gift card gets you $30 worth of food later, so. The only other item I think that I have for board topics is next week we'll be doing the superintendent's evaluation in a closed session, and I've talked to both Hala and Natty, but the people that will be involved in the evaluation will be the people that actually participated with the survey, so it'll be the four of us that'll be doing the evaluation. Any other board topics?
I heard that a while ago, the board members did a kind of a personality survey, interest, or description of our personalities and how we can work together to better become a team. Was that going to be done for the other school board members, or is that something we
The
can look at?
color one you're talking about?
Right,
Oh, it was kind of fun.
Like the Myers-Briggs?
in a way.
In a way, it kind of goes down that path, but it's a whole different, if I think about it, I'll bring my book in. We can certainly have that conversation, Superintendent Kelly. We could,
Was it green?
yeah, I don't remember what you were.
Huh?
I said I
was
don't
yellow.
remember your
You were
color.
yellow, right.
You were green.
I was green, yeah.
That was great.
I'll bring the book so it makes sense, so.
Yeah.
You were red. I remember
There
that.
might have been a little bit of red in there, yes.
And Lori was yellow,
I think it would be very insightful, interesting.
Okay.
because Lori was the loop.
I also want to mention, I attended the Heights Next meeting. I forgot to mention that in our report session. Heights Next, if you don't know, is a group that's been formed to help bring together the various groups that are in our community to help, like Lions, Rotary, so forth, to, and Kiwanis, I don't want to forget anybody, to all have a common communication forum to work together. So I would just, it was a great meeting and a great opportunity for the school district to be involved in. And I think might have been a representative there. But they're going to be meeting again.
Anybody else? Board topics?
Is there a GoFundMe set up for the All-American City?
There is. It's GoFundMe dot allamericacity. I think it's actually GoFundMe
Okay.
dot allamericacity. It's, you know what? Yes, there is, and I don't know what it is off the top of my head. I was going to look it up, but there is a GoFundMe account. If you go to, the district has, I don't know if it's on the flyers or not, do you know? Yeah, I'm just trying to remember if it's on the flyers. I know in fact, I just looked at it today. I would encourage you to look at the school district's website. I know the flyers are up there with the information about the fundraisers. It may be listed on that.
Okay.
And if it is, then it would be on the same flyers that are on the fire department Facebook page. But, yeah, I apologize. I know it's All America. Is it a .org normally, the GoFundMe account?
I think you go to the GoFundMe website and just look it up.
If you just, I know it's
Yeah.
All America. I know it's that. I don't know what it says right before it or after it. But it's CH All America for Columbia Heights. So.
Well, if you find it, you can share it on Facebook
Yes.
from the district's thing, and then nobody has to go look up anything.
Yep, so maybe Casey, you can chase that down and put it on the schools. But I think it's CH All America GoFundMe.
So another
CH All America.
opportunity to donate.
Yep, thank you, that's a great idea.
Can it be
So
put on the school website?
The fundraising is being advertised if it's part of a,
We put up posters and things for this because we're working on it.
Oh, because we're
collaboratively.
working on it collaboratively. Okay, okay. Just want to make sure that we're not crossing any lines there.
thank you. Anyone else?
Yep, work.
If not, we will adjourn the meeting at 9:30. Thanks, everybody.